everyone who's here. If you're here for Andre, I'm sorry. He'll be here later, and he got called away for some cyber matter, which is pretty typical for the course. So what I wanted to give a little bit of a talk on some increasing conflicts that are coming up in the workplace between cybersecurity and employee privacy. I thought this is an interesting topic. It's actually not covered that often, but it will start to be covered more often as we move forward. We're seeing a lot of developments around personal privacy. People are taking a lot more interest in it. There's a lot of new laws and regulations around the world and now in the United States, especially in California. And the Congress and regulators are starting to pay attention to it. Employee privacy is a little further behind. So right now, not much happening there, but as I'll point out a little later on, there are starting to be some points and places where employee privacy is starting to become an issue. And so the first real question, this is what I was thinking about is, so when you have cybersecurity needs in an organization, and that increasingly means a lot of monitoring to understand what's going on within the enterprise, but on the other hand, you have employee privacy considerations, so who wins, right? Which one ends up on top? And the answer is cybersecurity wins, pretty much all the time. So when I asked the question, then I answered the question, I felt like we were done. Cybersecurity wins, and we move on. Employees don't have privacy when it comes to cybersecurity needs. That's really the bottom line, but I started looking at a little, with a little more attention around what are the factors, what are the issues that come up, and how can we kind of further address the risks or balance the needs of employee privacy, and when will that come up? And so clearly, privacy is important to employees. Ultimately, there's a morale factor to it. Employees do not like to be monitored. The idea that someone's looking over your shoulder, the idea that there's a camera above your desk and above the cafeteria and everywhere you go is obviously a detracting factor for employees. You want to just, in the scheme of things, right, employees now are on open desk plans very frequently. There's a general sense that they've lost their kind of space and they don't have the kind of privacy that they used to have. And so now going a step further for employees to think that there's a camera above them and everything they do on the computer is being monitored 24/7, it further detracts from morale of employees and whether they feel comfortable in a particular environment. There's traditional expectations of privacy. And as we'll talk about a little bit at the end, there are some expanding data privacy protections for employees. And so we're going to have to find a way to deal with that. At the same time, we have to maybe be even more aggressive in cybersecurity practices. Certainly monitoring is becoming not only something that companies want to do, but something that companies have to do. There are, especially in the financial sector, obligations on a company to be monitoring their employees. So banks and the like need to be monitoring communications. If they're not, they get in trouble with regulators. There needs to be a good amount of monitoring to detect external attacks as well as insider threats, which can be the worst kind. And so companies are finding new ways and new reasons why they need to monitor. And sexual harassment and other kinds of workplace activities are increasingly getting a lot of attention, and companies need to be proactive in monitoring to detect and remediate those kind of incidents when they come up. And one of the things that really got me on this topic was a Wall Street Journal article this past August about new ways your boss is spying on you. And so when you start seeing these kinds of articles in the papers, what this means is these kind of issues are bubbling to the top. These are kind of issues that starts off in an article, and then it triggers 3 or 4 other articles, and then a congressman asks about it at a hearing, and then there's talk about new guidance, and then there's a couple of lawsuits. And so it starts off in the paper, and these things tend to pick up over time. And what's interesting is if you try to drill down to all the different reasons why companies are doing monitoring, cybersecurity is a big factor in that, but it's not the only factor. And to me, I think it's one of the most legitimate reasons why companies are going to have to monitor their employees. However, there's a lot of others, and some of them can veer into, the creepy context. So there's a lot of monitoring for performance evaluations and quality control. And you just think about a classic example of being a call center. There's no employee monitored more than probably an employee who's in a call center. They're in a clean desk environment. They have a very limited computer. Everything on the computer is being monitored. Every phone call that they take is being monitored for quality control purposes. There's cameras everywhere. And so, that's the most extreme environment, but we're starting to see very similar approaches being adopted across a much larger number of workplace environments. And so companies are thinking, well, if we're going to do performance evaluations every year, how can we determine how productive our employees are being? What percentage of their time on the computer is spent on Facebook or doing other things or on social media? How can we monitor for those kinds of issues? Where are there distractions? And sometimes these are very legitimate reasons. For example, companies develop new software. All their employees are using various software applications that they've developed. Some of them are just painful to use, and the functionality isn't good, and the user experience is terrible, and so they want to monitor all of those things so they can understand where their employees are getting frustration. Allocating resources, different departments, how they're performing against each other. And then we talked a little bit before about discovering issues in the workplace, and monitoring is obviously a key way of doing that. And so those are non-cyber issues, and I think that's where the growth is around monitoring, is primarily in those areas. And companies, the same way they want to monitor consumers in every way, every click you make on a website is being tracked, and they're trying to find ways to do targeted advertising or understanding the user base. Companies are saying, well, instead of just collecting all that data and doing all this creative analytics on our customer base, why don't we do it on our employee base? And so that's where companies are starting to go. But we'll focus on the bottom three for now, which are different kind of variants, and they're going to overlap. But the first one is protecting against outside cyber attacks, external threats. The second one is internal, insider threats, and the third one is related, which is legal compliance and law enforcement. So even if you trust all of your employees, you just think they're all wonderful people and they would never do anything wrong, you will have legal requirements to monitor them to some extent. Financial sector more so, other sectors less so. And then there's times that law enforcement will also need certain things to be monitored, or you will want to prosecute certain crimes that were committed, and so you will need the data that you obtain through monitoring. So I'm going to focus on these bottom three, and we'll talk about some of the techniques that we may use just briefly. But protecting systems, so frequently now everyone has some form of endpoint agent. Used to be just an antivirus, but now those endpoint, so that software tool on every single computer now might be monitoring a much wider array of behavior than just antivirus searching for those kind of threats. A lot of tools out there will be tracking pretty much every file you open and that kind of activity. Network email scanning is pretty much a given for everyone. But not only is it just where the email is coming from, the metadata, but the newer technologies are actually analyzing the content, and then there's access logs for everything now. And companies are not only logging more information, they're keeping it longer, and they're finding ways to use it. The second one, insider threats. So you can think about some additional tools that might be put into place, like call recording. So we're phone calls, CCTV cameras throughout the workplace. The one that struck me at my prior firm, they redid the office space and they put a lot more cameras up in the hallways. They didn't put them into offices, but they put them throughout the hallways, and the offices had glass walls. So I guess they were in the offices. And they also put them in the cafeteria. And there was a terminal in the cafeteria where certain foods were out 24/7, and you can go and you can check yourself out and pay for it. And they said they trust everyone in the office implicitly, but there's a camera right above the checkout table. And so, people start thinking about that. Well, I'm going to be sitting in the cafeteria with my friends, and some cameras can be recording us. And so, people start getting uncomfortable about those things. And then finally, when it comes to legal compliance, we've seen this, especially on the law enforcement side, literally taking entire system images. So sometimes they would have to come in and take your physical computer, make a copy of the hard drive. Now they can do that automatically. You don't even know that they're doing it. They kick off a process and they can image your entire hard drive. And a lot of insider issues are resolved with system images. So there's concern somebody's busy copying computer files onto a USB drive and taking them home. Well, they can take a system image and there's log data buried in the computer, in the registry, and other places where they can see which USB drives were connected, when they were connected, what kind of files might have been moved over, and that's particularly important in law enforcement. So, a top salesperson leaves, goes to another company, and magically he has his customer list, he has contacts, he has all sorts of information, and company starts doing an investigation of system images or data that they had, and they are able to figure out that he made a copy of all this information before he left. But I'm going to flip this over now. So let's talk, and I think it's important to think about this when we talk about privacy rather than cybersecurity, and cybersecurity too, but really more on privacy when we get into the legal issues is not to think about the tools that we're using, as we just talked about, but really focus on the data. And so instead of talking about endpoint agents and access logs, what are we talking about here? We're talking about people's emails, their devices, their phone calls, social media, biometrics, their location. Those are really the data points that conflict with privacy. And so, any of us, both as practitioners but as individuals, will often feel conflicted about these issues because as a practitioner, some of this stuff has to be done. As an individual, you don't appreciate it when it's being done to you. And so I think, when we focus on the data, we very often can kind of personally feel invested in how these things can be used for the company, but also maybe make us uncomfortable. I'm going to run through them fairly quickly, and I've identified some cases just because I'm a lawyer, and I feel compelled to do that every time I put anything together, but I'm not going to get into that. I'm really going to talk about some of the high notes here. So work emails, internet activity, generally fair game, and that's like step one for every company. Phishing attacks and business email compromise and viruses. Companies are monitoring all email traffic and internet activity. Generally, though, this is on employer-provided systems, devices, email accounts, and things like that. And we'll talk about personal in a moment, but one of the things that really is important is employee expectations. And so how do you set employee expectations for privacy? If an employee knows that their work email is being tracked, then if they're going to send some perhaps controversial opinions, they will know not to do that on their employee email. The golden rule I tell every company, no matter what I'm involved with I'm helping them with, is that they should never put anything in an email if they don't want it to be on the cover of the New York Times or in front of a judge in court. It doesn't matter what the context, what the situation is, anything you put in writing will show up somehow, some way. And I've seen this happen in practice, and it looks horrible in hindsight, and at the time, it was a trivial, off-the-cuff comment that somebody made. And so When we set those expectations, work emails, internet activity, fair game, personal emails, personal devices gets a little trickier, right? So employees have an expectation that their Gmail account or their personal Microsoft account, that's personal, that's private, the company is not going to be prying into that. This gets challenging when people blend their use of accounts. They use their personal account for work stuff sometimes, they use their personal chat for work stuff sometimes, and we see this going up all the way to the government, where we've had very public incidents of people using their personal email to conduct work business, and what a controversy that caused. But this happens every single day in virtually every workplace. People are texting on their phone with their colleagues and their buddies and their clients. We'll talk about bring your own devices a little bit too, but the idea behind bring your own device policies and procedures is really to strike this balance, because very often we encourage or we support employees using their personal devices, but at the same time we need to set ground rules. We need to set what the expectations of privacy are going to be when they're using personal devices in a workplace. And this is really important from a legal perspective, because the courts are very focused on what the expectation of privacy is. If employees expected their personal accounts and devices to be personal, then for a company to pry into it is breaching that expectation. Whereas if company sets the ground rules properly and the expectations are that the company could look at that information, then the courts are much more inclined to respect that. Phone calls. So this one is actually tricky. Companies can monitor phone calls if their employees are aware of that, and there's some paperwork somewhere that says be aware we're going to monitor some of your phone calls. But some states, this can trigger wiretap issues. And some states like California require that both sides of a phone call be aware that the call could be monitored. So that's fairly easy, and that is the reason why you get those automated, this call may be monitored for quality control purposes. But when you're having a normal phone call with a contact at a company, you're doing business with them, you give them a call on their company line, you're not calling a call center. There's no automated message about being recorded, and so if you're an outsider calling someone in California for some business discussion, and you're not aware that your call is being recorded, that can be very problematic. So we need to be a little bit careful about these kind of issues. The one of the ones that's really, I think, going to become a much bigger concern is video surveillance. And so historically, you had some cameras, other than some guy in security sitting in the security office, nobody ever looked at these things. They were cycled on a 24-hour basis or a 7-day basis. They were never associated with individuals, so it was just a raw recording of an office space, of a lobby, but we're going to start getting into facial recognition issues, right? What happens if you have a photo of every employee in the company, and as they walk through your hallways, you're actually able to record who they are at any given time and where they're going? That's going to get a lot trickier. Another really big issue is going to be audio recordings. And so CCTV doesn't have audio, but what happens when companies decide, hey, we'll put audio in there too, why not? Then you start getting into wiretapping issues. And so, again, expectation of privacy, but also some laws around recording audio. Now, think about it. If you're sitting in a cafeteria and they have some camera in the corner, that might be one thing, but if you're having a friendly conversation with 3 of your friends during lunch, you don't want that conversation being recorded. Social media, this is another, I think, very challenging touch point, which is a lot of employees are using their own social media accounts to talk about their job, about their products. They want to promote what they're doing. Think about LinkedIn. People have a personal LinkedIn account, but constantly posting about, I'm speaking here, we just came out with a new product, or we just announced a strategic joint venture with so-and-so. you're using a lot of personal social media accounts for work purposes. As a side note, we've had clients have really tough issues with this. So your number one sales guy has built up a social media following of 10,000 followers, and he uses that to influence and promote the company, and then he quits. So now who owns those 10,000 followers? Because it's a social media account on his name. He says, that's my personal account. I'm going to your competitor. I'm going to tell my 10,000 followers to start buying your competitors' products. And so companies need to start thinking a little more, professionally around how social media is being addressed with your employees. Are they using a company-owned social media account? Are they using a personal account? What can you track? And who controls it? What rights do you have as a company over those practices? A number of companies have run afoul of various rules here around labor practices, free speech, and other things. So, if that same salesperson doesn't go to your competitor, but he starts bad-mouthing the company because he had a bad falling out with the company, that could do a lot of damage, and you tell him there's going to be defamation suits and other stuff, and he says, well, free speech, I can voice whatever opinion I want. So companies have to think about, what the social media strategies are going to be around there and what you can control in that environment. Biometrics, this one's really interesting, primarily because of Illinois. They are among about 3 states in the country to pass a biometric law that says you cannot collect biometric information from people without appropriate notice to them and getting their consent. The difference is that, unlike the other 2 states, I think it's Texas and one other, Illinois said that if you don't do that, anyone whose rights you violated can sue you. And so this has become a phenomenal ground for class action lawsuits. And we've seen 2 kinds of lawsuits. One have been the consumer-oriented lawsuits, so consumers suing. Facebook's currently in a lawsuit there because people accuse them of facial recognition on tons of photos. And when you do that, you're taking a photo and then you're basically converting it to biometrics, because as soon as you link a name to a picture, that's biometrics. And so there's a number of lawsuits going around with consumers. I think Six Flags, there's a big case there, people going to Six Flags. They were taking either photos or fingerprints and using that to get into the park or get into rides. And they've been sued over that. But there have been a whole bunch of lawsuits under this law against companies, against hotels, and other businesses that use biometrics to track employees. And so a hotel might have all of their staff clocking in and out with a thumbprint or going into or out of floors. And what those employees have alleged in these lawsuits is you never got our proper consent for this. It's a nice way of an employee who leaves the company to make their mark, to sue a couple of days later. Do you have a question?
Yeah, what exactly would you be consenting to? It seems pretty vague to me. So,
if you want to use thumbprints for a time clock, for timestamps of your employees, you need to very expressly say, this is what we're going to do, and do you agree that we can do that? So usually that's going to be, the employee starts their employment with you, and that's going to be among the paperwork. The problem is when you put in a biometric system, while you already have an existing employee base, and you're not going around to get every employee to sign a new form, you don't have consent. And so what tripped up, I think, a lot of companies is that they were implementing biometric systems instead of the paper clock in, clock out. Now we have this fancy new biometric system, and they didn't have all their new employees consent to the new practice. And so now you've got the thumbprints of all your employees without their permission.
If somebody didn't agree to that consent,
yes,
is there grounds for discrimination by not consenting to sharing biometrics?
So that's a good question. In the U.S., generally speaking, if you want to be an employee here, these are the conditions. It's very rare that you get to negotiate those terms as an employee, that you get to negotiate the fine print. And I think that's going to be true for all of these things, right? When you start off in an organization and they have some notice and consent forms and that stack of paperwork together with your 401k policy and your health insurance packet and all of that, you don't really get to negotiate that. In Europe, this can be more challenging because Europe has much stricter employee privacy laws. And so the idea of getting consent from an employee in Europe, they've basically called that out as being a joke because employees don't have a choice. And so in Europe, consent can only be a legitimate way of collecting information if it's freely given, which means they're not compelled to do that. And so Europe actually has some challenges, and I'll touch on this towards the end. Europe, you cannot rely on consent. There are some other legal bases. There might be legitimate interests. There's some vague legal bases on which companies can collect information about employees without relying on their consent as their legal basis to collect. Because they recognize there that consent with employees is a joke. I mean, employees don't have a choice, so that's not consent. Yep.
Have you run into any cases where employees have consented, given the biometrics, and then that data has been compromised? And what liability is that?
So that's starting, and that's a great question. I think the big fear with relying on biometrics is, on one hand, hey, this is a fantastic way to secure information because it's very hard to just, it's not like a password. The biometric is tied to the user. On the other hand, yes, once it gets compromised, the harm to the individual is much, much higher because they can't change their fingerprint or their retina. So there have been a couple of cases. I think there was one or two in Europe where a massive amount of like 150,000 or even higher number of biometric data points were stolen. I think it's still early days, but those suits are going to be very interesting because it's one thing to say, hey, we lost your password, but no harm, no foul, just reset your password. People are going to claim that there was some real harm being done by biometrics because they can't replace that. I think this is the last one that I wanted to just touch on is location tracking. And so this is also a very sensitive one. So biometrics being one really sensitive touch point, location tracking I think people are very sensitive about. There's going to probably be some new laws in the next couple of years specifically about location tracking. That's going to be a focal point. That's considered, you might say, a sensitive form of personal information, is where people are at any given time. And so clearly, there have been allowances and an understanding made that if you're driving a company vehicle, if you're driving a FedEx truck, they may have a legitimate reason to know where you are on that truck and where you're going with it and what you're doing with it for various reasons. It starts getting a little iffier when you're talking about a non-company vehicle. And there have been actually some discussions around trying to force employees to wear, Fitbits or some other, watch or some other personal device where you can track where they are. Particularly if you're dealing with employees who work in a warehouse, right? So you want to see how effective they're being. Are they sneaking off for a 45-minute break? Or are they in the warehouse coming and going, and you want to track that activity? There's some states are not thrilled about that idea. They think that's too invasive. So I think location tracking is something we're going to see some additional developments on. And again, for cybersecurity, those things can be important as well. But best practices for monitoring, and I think we need to think about this on two sides. One is on the employee side and one is on the cyber side. And the employee side goes to what I mentioned before about expectation of privacy. In the United States, historically, both for consumers and employees, the general model that we have for privacy is notice and consent. In other words, we need to explain to people what information we're collecting, how we're using it, what we're doing with it, who we're giving it to, and then get their consent. This comes to the forced consent issue, right? So if you go to a website, just one second. If you go to a website and, it's, hey, you agree to the terms of our privacy policy, you don't get to negotiate with the website operator on what their practices are. So it's kind of mandatory consent. If you want to buy a product from our website, you're agreeing to our privacy policy. Europe is trying to get away from that because they say that consent is not freely given, so what's the point of it? And what they're doing is they're saying instead of doing consent, we're giving consumers certain institutional rights. You cannot do certain things with their information. You cannot just change the terms on them whenever you want. I think in the United States, we're also experiencing a little bit of a shift, and I'll talk about it in another slide. But right now, especially in the employee context, it's here's how we use your information. You're going to sign to agree that you read this and you understand this, so that you do not, do things that you would be uncomfortable with that are going to be recorded. You guys have a question?
Something I realized is almost every login screen I've seen in any kind of corporate, even educational environment, not so much educational, the words "no expectation of privacy"
Yep.
have been everywhere.
Absolutely. That's been, and that's on the kind of the fourth one over there is the login screen notices. And you didn't see that 10, 15 years ago. Now you see that on virtually every corporate environment. As soon as you log in, it's, hey, you have no expectation of privacy in this system.
Does that work in Europe?
Not as well. So what Europe has said is that privacy is a fundamental right. It's like a human right there. So with that expectation, you cannot just have employees sign away their fundamental rights. And that is kind of a God-given right that all people have in Europe. It's a human right. It's part of the charter of the EU. And so you can't just have an employee sign a paper that says, I give away all my rights and you can do whatever you want with my information. No matter what the company does in a notice or what kind of signature it gets from the employee, there are going to be much more restraints on what they can do with employee information. And they're starting to have a bunch of cases in Europe about employee privacy issues. I'll talk about one in the next slide is employees in Europe, like consumers in Europe, have rights to find out what a company has done with their information, what information they have about employees, and that might start coming to the US too. And so what that does is it's no longer a black box. Like the company can do whatever they want and we have no idea what it is that they do with it. In Europe and potentially in the US, people will have the right to get that information. So think about it in Europe, employee gets fired and they immediately request a copy of their HR file. Performance evaluations, they want to see it all. See communications between their managers about them, anything else talking about them, because that goes to their personal information. And that becomes a very tricky issue. Did anyone else have a question? Sorry. Okay. On the cyber side, really I think what we need to do as cyber professionals is responsibility around employee data. So policies and procedures for how the cyber professionals operate when it comes to employee information. But we need to think more carefully about limiting collection. So not just collecting it for collection's sake, but what are we collecting and why? Very important to limit access rights, right? The worst case scenario is, when it breaks that the IT employees were busy looking at videos and of personal emails of people for, because they wanted to, or because they try to ask such and such person out and they said no, and now they're curious about what they're up to. Those kinds of things are just horrible, and that's where things just go haywire. And so to be responsible about how this information is going to be used, companies need to be much more careful, and they're starting to much more so nowadays about limiting access rights to those files, that data, limiting use cases, limiting retention. I mean, you don't need to keep stuff for 10 years, and you won't keep it for 10 years. By doing that, we're able to collect the data for the cybersecurity measures that we need to have in place without risking these kind of misuses of employee information. So to some of the points that were made here, there's a very interesting case that came out in the Supreme Court of Pennsylvania that held just as a matter of common law. In other words, there's no statute that says this. They just came out and said, in our view, as the Supreme Court, we think every company has to exercise a reasonable care to safeguard employees' sensitive personal information. In other words, if you have employees' HR files, social security numbers, bank account numbers, payroll information, you have an affirmative duty to protect it with cybersecurity. This was like a hospital network that got sued because they had a data breach of employee information. And so now the company is being sued for not protecting that information. This is really interesting because there have been about 6 or 7 states that have had this issue, and a few of them came out on the other side. I think Georgia, being one of them, said, no, there's no such, we're not going to make up some new duty to secure employees' personal information, whereas Pennsylvania did. And people don't even see this anywhere. There's no law that says this anywhere. It's just a court case. But now anyone could sue in Pennsylvania if their employees, as an employee, if their information gets hacked. So that's going to become increasingly important. That's going to come up in California too. So California has this incredible new privacy law going into effect this January. One of the things it does is there's a statutory penalty for a data breach. In other words, a victim of a data breach can be entitled to $100 to $750 if they get hacked. In other words, they don't have to prove that the loss of their information created some kind of harm for them. If the company did not have reasonable cybersecurity and got hacked, people can sue. And this is not just for consumers, but also for employees. And so employees are going to start collecting on this. One thing that it does is it gives consumers some of these EU rights. So based on the EU privacy laws, it says a consumer can come to you and say, I want you to give me a copy of all my personal information that you have about me, including any kind of profiling that you've done, any information you've gotten from third parties. I want you to delete that information. Or it can say, I don't want you to disclose that information to any third party other than your service providers. And this one, hang on one sec, this one is coming in January, and it's going to be huge. A lot of companies now are, and this is for me becoming 80% of my job, everyone's working on getting ready for this. What's interesting is originally it included employees too. Employees, job applicants, others. They just put through an amendment that should be finalized, signed by the governor this week or next week, excluding employees from that portion of it for 1 year, and then it sunsets. And so the question is, they may be passing some form of employee privacy law this year, and so that will replace this. If not, employees are going to have the same right, like the EU, where they can say, I want a copy of my HR file. I want a copy of the emails that the management were sending around talking about me and whether to promote me or not promote me. And so this is going to get really uncomfortable for a lot of companies. And think about if you're collecting all this information for cybersecurity purposes, employees are going to make a request. They're going to want access to all of that information. What kind of videos have you collected about me? What kind of email traffic have you collected about me? And I want a copy of that. You have a question?
Small one?
Yep.
I'm just going to think, an immediate thing I can think of that is, okay, so let's just get rid of all their data centers in California.
Or the what?
Their data centers in California.
So it's a California resident. So if your center's in Nevada or Colorado, it doesn't matter. As long as it's thank you. As long as it's a California resident, the law applies. And California resident could be on vacation in New York, and the law applies, as far as California is concerned. Yep.
Affecting downstream vendors, third-party service providers as well?
Yes, so this is turning into a supply chain mess. That's a nice big chunk of this. And there's going to be really 2 buckets. There's going to be strict service providers. So if you're a strict service provider of a company, you're basically like the company as far as this data goes. As long as you can only use the data of their employees or their consumers to service them, then you're basically effectively a piece of the company. So if the company needs to turn something over, they will go to you and say, you need to cooperate with us to help us turn this information over. However, you're not considered a third party, like they're disclosing information to you. The second bucket are third parties. So historically, companies would maybe give out email lists to third parties as part of some kind of joint partnership that they would create. You might have third-party cookies on your page, and it's sending data to various trackers, and you're getting some benefits from that, but those third parties can do whatever they want with that information and sell it to third parties or monetize it some other way. Those are third parties, and if you get a do not disclose request, that means you can no longer share with those third parties. So logistically, this is a pretty big headache, and every company is going to be getting a whole stream of letters, especially vendors, over the next few months saying, hey, you got to comply with this new law, and you got to tell us what you're going to do to comply with it. And it's going to turn into a pretty big operational challenge, because it really is not just like a legal statute, oh, we update our privacy policy. There's going to be some operational changes in how we use data. Even stricter requirements in the EU, as we said, around employee consent, things like that. And so just, and I know we're at the end of our time, so just a couple of quick ones. Where do you need to be on alert? Internal investigations, non-employees. A lot of times you have contractors, visitors, they never signed any notice when they got hired, and you're busy tracking their information. That can trip up a lot of companies. Undisclosed collections or use. Companies have this mentality that once we have the data, we can do whatever we want with it. And kind of what the EU and California, what these laws are starting to force down is the idea that just because you collect it doesn't mean you could use it for whatever you want. You can only use it for the reasons that you originally collected it. Sharing with third parties dangerous, misuse we talked about. And so I think what the cybersecurity world needs to be mindful of is that we're collecting a tremendous amount of really valuable data for legitimate cybersecurity purposes, and employees respect that and understand that. What's going to happen is companies are going to say, hey, we have this data, we want to use it for some other reasons too. We're collecting it already anyway, why don't we use it for other reasons? And that's where I think companies are going to have to start being careful around their policies and procedures. So with that, I thank you for your time. I think now we are done. And I appreciate everyone who came. I'll stick around if anyone has any questions.